So the accused persons who are Frederick Oleleliman, hereinafter the first accused, Stephen Cheburet Morogo, hereinafter the Section 204 of the Penal Code provides that any person convicted of murder shall be sentenced to death. An unlawful act or omission is guilty of murder, and then Section 204 of the Penal Code provides made various pronouncements on the issue of murder, and there is now judgment of the Supreme Court in presence Kariuko Muruatens of doubt. This order does not disturb the validity of contemplated. As a consequence of this decision, paragraph 6.4 to 6.7, offender, C, whether the offender pleaded guilty, B, character and violence in response to gender-based violence, F, remorsefulness of the offender, G, the possibility of reform and social readaptation of the offender, and then H, any other factor that the court considers relevant. We wish to make it very clear that these guidelines in no way replace judicial discretion. They are advisory and not mandatory. They are geared to promoting consistency and transparency in sentencing hearings. They are also aimed at promoting public understanding of the sentencing process. This notwithstanding, we are obligated to point out here that paragraph 25 of the 2016 Judicial Sentencing Guidelines states as follows, that is a quote, guideline judgments, where there are guideline judgments, that is decisions from the superior courts on a sentencing principle, the subordinate courts are bound by it. It is the duty of the court to keep abreast with the guideline judgments pronounced. Equally, it is the duty of the prosecutor and defense counsel to inform the court of existing guideline judgments on an issue before it. Now, the circumstances of the offense. In respect of the first accused, the evidence adduced before this court was proof that the murder of the deceased was premeditated and that it had been hatched by the first accused, who was the master plan, several days before the date of the execution of the plot. Now, the conspiracy involved high-level planning and organization, meticulously carried out. It involved sophistication and the use of technology with mobile phones and police radios. On the material morning, the victims' movements were monitored in and around the courtroom at Mavoko Law Courts. Eventually, they were trailed, abducted, and ferried in the abductor's vehicle, that is a private car, to a container at Syokimau AP post. They were locked up at midday and detained until nightfall without food or water. From the circumstances of the offense of the case, the following are the aggravating circumstances or factors. 1, the murder was intended to interfere with the course of justice. 2, the offense was committed by a group. 3, the deceased were kept inside the boot of a car and taken out one at a time to be murdered. The murder was executed close by so that the victims could hear the thumping and blows being inflicted and the screams and shouts or groans of their colleagues as he was killed. The fact each knew they would be the next to face the same fate, this must have caused them extreme fear, stress, and psychological torture, that is to the victims, as they waited for their turn. Now, 4, crude weapon was used to batter the victims to create the excruciating pain to the victims. 5, the deceased were put in gunny bags and plastic bags and dumped into the river with the intention to conceal the murders and make the recovery of their bodies difficult. The murder involved flagrant and excessive use of violence on the deceased and caused damage, of course, to their persons. 7, the first accused, while he clearly had a grudge against the deceased Mwenda, he captured and killed the deceased Kimani and the deceased Mwerori, not caring about their lives and the fact that they had not done anything to him to deserve what he did to them. They were collateral damage, and I must add that not that Mwenda deserved the judgment that he received from them either. Now, the first accused, being a police officer who had been employed and paid a salary with public funds to protect life and preserve property, acted in flagrant abuse of his office and acted contrary to the duties and responsibilities he was employed for. Now, also the offense involved detention and inhuman treatment of the deceased persons. Now, the issue of culpability, the first accused shot the deceased Mwenda 1 year before the incident, which is the subject matter of this case, even though the injury was very severe, being a gunshot wound that involved the hand and the upper chest. The first accused, after taking him to a clinic for first aid, took him to the Mavoko police station, where he locked him up in the cells for 3 days before charging him in Mavoko law courts with several criminal charges. That was the beginning of a prolonged and sustained harassment against the deceased Mwenda, until out of sheer fear for his life, he approached International Justice Mission, that is IJM, and Independent Police Oversight Authority, that is IPOA, for help. And he got help because IJM gave him a lawyer to represent him in court, another lawyer to act as his bodyguard, and every time they went to court, a taxi to ferry him to and from the court. In the meantime, the report Mwenda made with IPOA gave fruit, because eventually the authorities summoned the first accused and other police officers to make statements in regard to the complaints. It is the commencement of investigations by IPOA that triggered the delicate and meticulous planning of the murder and the eventual execution of the deceased. In that regard, I have considered that the first accused mounted a sophisticated master plan which saw him capture the deceased Mwenda together with all those who were helping him on the mid-morning of the material day. The first accused was acting out of self-preservation when he planned these murders. His was a personal vendetta against the deceased Mwenda for reporting him to IPOA. The aim, of course, was to destroy evidence by destroying the complainant, which was not only drastic but draconian and an extreme action to take. For the second accused, he stood by his colleague, the first accused, and stuck with him in every step on the material day. The judgment speaks for itself in this regard. He did not have any personal vendetta against any of the deceased. However, he played the critical roles of abducting and holding the deceased at his police station or police post, where he was the senior officer in charge of duty. Now, for the third accused, her role was to keep the deceased persons at the police post, where she was the sentry and report officer, all the way until the time that the deceased persons were removed from the post and taken away to be murdered. I have been asked to consider that she was the youngest and the most junior in the group, and even though not requested, I've also considered that she was the only lady in the group as well. Now, being a police officer with firm, stringent pecking order system, and being junior has significance in the need for discipline and order in the force. That discipline and order cannot include aiding, abetting, and enabling crime, and eventually concealing and denying any knowledge or involvement in it. Had she been candid at any stage of the investigations or the trial, which could have been a factor that could serve as a positive extenuating circumstance in mitigation. I noted also that even in the mitigation by her counsel on her behalf, she denies playing any role in the matter. However, to her credit, she was candid to the police probation officer and admits negligence in her place of work on the material day that was facilitative in nature. She played a role which is not peripheral, as Mr. Keegan suggested. For the fifth accused, he made a confession to the police, which I believe helped immensely in the investigation. It was his confession that shaped the investigations. His defense under oath was a further confession of his role in the whole murder. I noted the variations in his confession to the police and his confessions in his defense. He did not color anything white that was black. Now, I have carefully considered the mitigation of each of the accused persons as given orally and in writing, and part of which I have summarized in this ruling. I have also considered the various reports that were filed, the probation reports, medical report, the victim impact reports, as well as the certificates of the various courses undertaken by the accused persons during their incarceration. I have also considered the circumstances of this case, the meticulous planning, implementation, and the brutal execution of the deceased. To say the least, this was a most foul murder, an execution that was most heinous. I find that the most suitable sentence for each of the accused persons is as follows. The first accused is sentenced to death in each of the 3 counts. The death sentence in counts 2 and 3 are held in abeyance. Now, the second accused is sentenced to 30 years imprisonment in each of the 3 counts, with the prison terms running concurrently. The third accused is sentenced to 24 years imprisonment in each of the 3 counts, with the prison terms running concurrently. The fifth accused is sentenced to 20 years imprisonment in each of the 3 counts, with the prison terms running concurrently. In computing the sentences in paragraphs 2, 3, and 4, that is in respect of the second, the third, and the fifth accused, the prison authorities to take into account the period of each of the accused have spent in custody during the pendency of this case. I also want to inform the accused persons that they have a right of appeal against both the conviction and the sentence within 14 days from today's date. So those are the orders of the court. I think I'm done here, so I want to say thank you to all those who are involved in the matter, and I wish you all the best.
My lady from the bar, we have been here for 6 years. Almost what our lifetime in the bar. So if we could grant us just 2 minutes, I know you have that.
Now, I am now funked as official, Mr. Professor. You just want me to listen.
Maybe probably before you hear him out, there was some ruling that you were to give invitation to the motor vehicles and the phones. We had asked about that last time. And the application that had been made by the prosecution, they had objected to our application.
Yes.
And we said we still want the motor vehicle and the phones that were taken from the person. We would also be asking that we defund it to the full proceedings, including the sentencing. So that we can be able to lodge an appeal, which we do. On our part,
for the field accused. And as I think I can describe myself as a ward of the court, having been appointed to undertake this task.
You are a what of the court?
I am an officer of the court. I'm also
You know,
a ward of the court because
you come out with very interesting terminology. So what is yours?
yes, my lady just wanted to inform you to request personally for the court that the order that had applied to Ms. Kenyori should also apply to myself with regards to representation of the few that is possible.
So, Mr. Michoke, my advocate, as you have said, what is it you are requesting? So that I can now put it on in writing.
My lady, I'm just requesting. I didn't want to say the word, I was just requesting my payments in so many words. Given the many years that we have undertaken this task. without.
I don't know. We did not make any orders in the past.
There might have been an order, but I think it was overtaken by events or not considered.
Kenneth, I know you are with me part of the time. Did you make some order about his payment? You have not made. So you want your payments as per the 30,000?
No, my lady, I was asking the court to vary that to take into account the previous order that you had given with regards to Ms. Kenyori, the previous advocate.
I'm not sure whether that is the one I'm remembering. Kenneth, did they implement it? She just got 30,000.
No, my lady, it was implemented for my colleague.
But is the one who is with the books and things. Oh, she told you?
Yes. Off the record.
On the record, I'm being told it was not.
Yes.
On the record, I'm being told it wasn't.
No, my lady, because this matter actually began before the...
No, I'm talking about Mrs. Kenyori.
Mrs. Kenyori. It was before Mr. Kenneth came into the matter. It was during the longer time.
No, I know that, but he was also around. Yes. Do you know about Mrs. Kenyori? With certain... Okay.
My lady, then in that case, you can have both payments paid in kind for me and for Ms. Kenyori.
No, you're not representing her.
My lady, with your kind permission.
Yes.
If I may, on behalf of the third accused,
I don't know your name.
Ms. Wawero, my lady.
Sorry?
Ms. Wawero.
Oh, yeah, the lady who has been coming.
Yes, my lady.
Yes.
I'm holding brief for my learned senior, Mr. Katwa. On behalf of the third accused, we pray that her mobile phone should be released. And for purposes of the appeal, my lady will pray for a certified copy of the judgment and the sentencing.
Anything else?
This has been 6.5 years. And once again, we want to thank you and the sheriff. Thank you. We want to thank you, Sheriff, so many officers who have been very helpful in this process. The law has been developed in some areas, what are areas that are still to prosecution. The family have been steadfast, and even here today they are here. Following up on the course of justice. The ODPP must be appreciated, Office of the DPP. They did an excellent job, led by my former classmate, Nicholas Mtuku, and Ms. Betty again, and the team. We thank our colleagues for we also thank our colleagues for all the Special Defense Council parties and LSK led by the President and currently by the President. Eric, the way to speak so many presidents. Now currently led by President Eric, the William Vice President Wajia, and members of LSK who are very supportive with research and and International Justice Mission was being led by Senior Counsel President its investigative officers, this was a complex matter. What your judgment, sentencing judgment, sentencing, very sophisticated criminal syndicate or criminal enterprise. And the DCI and the security officers need to be thanked for making sure that all was done. The entire process, investigations, arrests, and unveiling the evidence, testimonies, etc. The media have been as objective as they can be, and that has really, really objective have helped foreground this matter for all these 6 years at the national level and even international, and that has helped a lot in securing the peace of process for the victims and their families. Of course, there has been the Witness Protection Agency, which played a very important role in a matter that involved very sophisticated criminal activity. So we just want to thank you, and we are also, in the course of this trial, 6.5 years, the judge saw it that go to the Court of Appeal. And while we will be missing you in the High Court, we are happy for you, and we are happy that the Court of Appeal will be recharged in the Court of Criminal Justice. That's a very important addition to the Court of Appeal, the bench on criminal justice. And I will stop there. I stopped there by lady. Thank you so much. We really learned a lot from you. And that's what I want to say. We really learned a lot from you in the course of handling this case. Thank you so much.
Am I shutting out anybody?
The DPP inside. I think that again spoke for DPP as well.
And I should have your proper title, which I have not mastered. Your title, official.
My title is Chief State Counsel.
No, that is the Chief State Counsel.
Yes, my current designation.
No, I'm talking about in this matter, you are not a Chief State Counsel.
I'm gazetted as a public prosecutor.
What is your rank, Mr. Mutuku? What was your rank? Let me put it that way.
This matter,
Yes.
I was a deputy DPP.
Yeah.
And while the matter was proceeding, I was declared to the Minister of Foreign Affairs. But then the DPP gazetted me specifically to prosecute that, to continue prosecuting the matter. I think I shared the gazette notice to the court. If it is on the file, I will furnish it. Yes. So what I intend to say is that Ben Sian has represented the state there in his pronouncements. Safe to say that we were expecting a ruling on the motor vehicle that belonged to the first accused. But as regards the phones that belong to the accused person, I believe once the order comes, they can only be served upon the DCI and they will deal with it. We had actually made a lot of presentations about those items which belong to the accused person and they were not part of the evidence. That's all, my lady.
Okay, as I hand over to the President, Mr. Ongaro has been very, very I have retired, my lady, from that.
Lady, that happens when you've been around for a while, as Mr. Sianya has been, and produced a number of students, some of whom I'm sure will appear through it. Already in the matter, my name is Eric Theory, the president of the Law Society. First of all, my lady, I want to join all the advocates who have expressed their gratitude to the court in the handling of this matter. My lady, we do know that it has been 6 long years. 6 years waiting for justice in this matter. There are so many lessons that we have learned from this trial, and we hope that in the future we will be able to determine our criminal cases in a somewhat more efficient manner, that we will not have to wait 6 years for the determination of case of this nature, considering that this was a direct affront on the administration of justice. And I know that I speak for the victims because they've agonized for quite a while. That said, lady, I want to, on behalf of the Law Society, really place our gratitude on record for the council holding brief for the victims and the council. They have exercised their brief in the most diligent manner, and the society owes them a huge debt of gratitude. And we are really grateful in the manner in which they discharged themselves before this court. And we are also grateful to all the advocates for the defense, also in the manner in which they have represented their clients. But at the end of the day, the winner in this matter is the rule of law and the administration of justice. We believe that this decision by this court is one that is going to shape jurisprudence and has enabled the growth of not just victim representation, but we've learned significant lessons in witness protection, the use of technology to detect and prosecute crimes. And so I know that all the advocates who are involved in this matter are proud to have participated in these proceedings. And as we end this matter, we recognize and remember the words that are set forth in our national anthem, that justice be our shield and defender. Finally, I thank you for giving me this opportunity to address you.
Lady, I've just received an instruction from my client. Might indulge me. Yes, my lady, but my lady, this one has to be written, unfortunately. Yes. My lady, it's with regard to the circumstances of this case. You are aware that the fifth accused has always been held at Naivasha prison for certain security reasons. He has asked me to ask the court to make an order that his committal should remain at Naivasha, where his security has been always secure through the proceedings. And going forward, with that, we understand that, my lady, but it's just in the very unique circumstances in this case. Yes, there is, my lady, but I'll do that. Yes. Yes, yes, my lady. I shall see him and have a sidebar with him.
It's okay.
Am I now allowed to adjourn this court?
Yes. Yes. Most obliged.
Oh, sorry.
Let's take a photo.